So you got hit by a commercial truck, and now it feels like everybody is pointing fingers at everybody else. The driver blames traffic. The trucking company blames the cargo loader. And meanwhile, you're sitting there with the injuries, the bills, and no clear answers. I'm Chad Romey, and this is Chris Blackburn, and we're personal injury attorneys here in Indiana. And we've held trucking companies accountable in cases just like yours. Because when the right evidence is preserved, these companies can be forced to pay. In this video, we'll show you the 3 ways liability can shift onto the company rather than just the driver, and how to use that leverage to protect your case and maximize your compensation so that you're not left footing the bill while the company walks away untouched. Christopher, when
Yes.
you're in an accident with a commercial truck, and whether that be a tractor trailer or a box truck, just somebody out there driving commercially, driving for a living, how do you go about holding the company, the trucking company, the commercial carrier responsible and not just the driver?
That is the name of the game when it comes to trucking companies, big box stores, Lowe's, Home Depot, things like that, is not just proving liability on the driver, but proving liability on the company. If you go to trial, there's a lot more to the evidence, and it's a lot more persuasive, if you will. There's a lot less sympathy to a corporation compared to an individual driver. So that theory is called respondeat superior, which is basically it's where the driver is on the job. If you can prove that the driver is on the job and in the course and scope of their employment with the employer, then the employer is on the hook. In our practice throughout the years, we've seen a lot of crafty arguments, tactics to try to, based on the defense that their driver wasn't in the course and scope of their employment.
Was on a break, was on a, I'm going to call it a side mission. He got distracted from what the actual job was going to run an errand of his or her own. And so they say, well, we weren't responsible for those actions because we didn't want the driver to be there anyway.
What it really becomes is they're trying to get the corporation out of the lawsuit, or at least not named in the lawsuit. So if it went to trial, the named driver would be responsible. Separate side road, they would probably still cover the defense under the insurance policy, but it's a tactic and it's a strategy for them from a defense to try to hold down some of the damages. Some of the other things that they will work on is Indiana law and federal law. There's a lot on this too. It comes down to employer versus independent contractor. So a lot of these companies will style their working arrangements with their drivers as if they're an independent contractor. So at least on paper, it looks like they're not doing, or they're not on the job. But when you really dive into it, and the law, this is where the law is going to be on your side, because there's, if I remember correctly, I think it's about a 10-factor test to establish, well, is it really an independent contractor situation, or are we talking employer? But the basic premise is, are they furthering the interest of the employer, or are they out there doing it on their own? So it gets really fact sensitive, and it requires a lot of discovery, written discovery depositions, a lot of documents that you're looking at, a lot of corporate depositions where you're talking to some of the corporate representatives, things like that.
Yeah, and ultimately, even if the driver is determined not to be in the course and scope of their employment, the insurance policy is still going to follow that driver. They're driving the truck, right?
Mm-hmm.
The question really becomes, can you loop in the company in case your claim value is more than the value or more than the coverage that they have? And so that's really important. Sometimes it's when we're looking at companies to try to figure out who's responsible, it's not just the employer, right? There are other companies that potentially could be liable in commercial, especially in tractor trailer accidents or in box truck accidents. So like the cargo loader, right? So somebody loaded the cargo, it was loaded improperly, it shifts during transit.
How about that?
Yeah, and causes either the truck to tip or the truck driver to lose control of the truck. And so it's not always just the company that you see on the police report. you have to act quickly on these things to find out who the corporate players are in your accident. Another thing that you can do, and it's not, and Chris talked about respondeat superior, or some people more broadly will call it vicarious liability, meaning the entity, the company being responsible for the negligence of their employee. There's also specific negligence that the trucking company can have done prior to the accident, and that's for negligent training or negligent hiring, negligent supervision. So basically, we don't just look at what the driver did that day. We look at what did the company do in the months or years leading up to that incident. It's all about painting a picture of, in front of a jury, hey, this just wasn't one bad moment. This just wasn't an accident. This was a pattern of behavior by the company that they don't vet their drivers, right? They don't properly train their drivers to either operate in a safe manner or to maybe evaluate the condition of their vehicle before they take it out. And so that is and frankly, a lot of corners are cut in that area. A lot of corners.
Especially at the smaller mom and pop companies. We say a mom and pop, but in our industry, and it's usually 1 or 2 drivers, 1 or 2 trucks, less than 5. They're just not a big, ginormous company that's operating all over the United States. Those types of, it's not to say that the big companies don't too, they do, but what you're looking for is, I could think of a good example. So let's say you've got a driver who has a known health history of falling asleep. Okay, his health isn't the greatest. So if a driver doesn't pass a health test, if you will, a physical, they're not going to be able to drive. Now, a company should be looking at the background. They should be doing background checks, should be getting health checks. If there are red flags, it's going to put the employer on notice that maybe Bob over here is a little overweight, has sleep apnea. And maybe they shouldn't be hiring Bob. They should be hiring someone else.
Yeah, the key is to make sure that you're looking at all avenues of negligence, not just Bob falling asleep, right? Not just the truck driver going through the red light or going a little bit too fast or not seeing traffic in front of him.
Maybe seizures might be a better one, where sometimes people don't know when they're going to have seizures, but they can prevent the seizures by taking the medications. So maybe that's a better example. But
Bob's got a lot of stuff. He's got the apnea. He's got the seizures.
Well, probably high cholesterol.
He's had a couple of heart attacks. He's a ticking time bomb.
But the company still hired him.
Yeah, the company.
Put him out.
The idea is that the company needs to make sure that they're not putting folks who are dangerous. And it's not that people with health issues can't drive trucks, but if there are health issues that cause you to be a more dangerous driver, well, that's something that trucking companies, the vehicles that trucking companies put on the road are enormous, right? And they're driving at 50, 60, 70 miles an hour, 75, 80. And so you want to make sure that the person operating that vehicle is a safe operator. And training goes a long way. Many times there's no training whatsoever after somebody's hired. So you want to be able to look at that to make sure they're keeping up with the standards. Speaking of standards, there's specific safety rules and laws that trucking companies have to go by, such as hours of service, right? So they can't allow a driver just to drive as much as they want over a certain period of time. They have to get off the road. And so sometimes the logbooks that drivers keep are pen and pencil, right? So it's just a logbook that they're keeping in their truck. A lot of times now you do have electronic tracking of vehicles, and that is really, really helpful when it comes for us to show how long a driver was out there. There's so much tracking on these vehicles now, especially the more sophisticated companies that you get. If you're ever in an accident with an Amazon truck, the tracking they do on these things is crazy, but you have to know how to read the data. You have to know how to get the data first, but then you have to know how to read the data to figure out was that individual who was operating that truck going by the rules, right? Abiding by the guidelines. And going back to what Chris said earlier, with Amazon anyway, you're going to have a big fight over independent contractor versus employee, but we'll go down that path in a different video. When it comes to rules and regulations, sometimes there's actual rules. Sometimes there's just kind of industry standards. Sometimes there's standards that are set out by the company itself, but then they don't even live up to that.
Right.
Like checking the vehicles. So some companies are very reactionary. They will fix the brakes when the driver tells them, hey, the brakes feel a little squishy, right? But sometimes brakes feel great for regular stopping. But when a driver needs to stand on his brakes because something's happening in front of him, well, they're not up to snuff for that type of braking. And so that's why actual inspections of the vehicle are very, very important. It's proactive inspections, not reactionary inspections. So safety rule violations can be a direct path to proving that a company is responsible beyond just them being responsible for their employee. And that is really important because sometimes those violations can be so bad, you can be talking about punitive damages, not just, hey, please compensate me for my loss, but punitive damages are designed to punish the other side. The law says, hey, look, you did something so egregious, so reckless, you're going to be punished for that. And it's punished with a monetary fine, if you will.
Think about the federal law in Indiana, and all the states have the pretty much a similar parallel laws, rules. But the Federal Motor Carrier Safety Act is going to be kind of the Bible for what you can and can't do. And it is a large book. I mean, it's very thick, and there is a ton in that. These trucking cases are never as simple as, well, the law says you can't drive for more than 11 hours, and Bob put in his logbook that he had been driving for 24 straight hours. It's never as simple as that. You have to, in order to find the federal violations, you have to do the discovery, go through the documents, vet the documents, and then really kind of compare them to what the law has. And so it's never as simple as that, at least for the cases that we all have. But those are slam dunks if you get them. But you're not going to get that because people don't admit to that. Pre-electronic logs, that it was very easy to fudge your logbook because it was all pen and paper. And so you could get really creative on what you were doing when you were stopping, when you were taking your breaks, where you were at when you're picking your loads up. It's a little bit harder now with the electronic logs.
And sometimes you'll see where the driver is being paid, so the payroll logs might not match up to the logbook. So hey, why were you paying him if he wasn't driving, right?
Mm.
So there's a lot going on in commercial trucking cases. So if you're in an accident with a commercial truck, you can get an offer, right? There's nothing magical about what we do in getting an offer. I think typically we will get better offers than folks who are unrepresented. But especially in trucking cases, you can get an offer that sounds like a ton of money. And they're going to tell you, hey, this is all of our policy limits. But you don't know that there might be 4 other insurance policies out there they're not telling you about, or there might be another company responsible. And so even if you get that big offer and you say, gosh, it would really be helpful to take that offer, before you sign anything, you talk to a lawyer. The lawyer might tell you, hey, that's as good as you're going to be able to do. But they also might say there are these other 9 things we need to check out before you sign on that dotted line. Because once you do, it's typically done. All right.
I was like getting the internal documents. The internal documents are great because this is the company saying, hey, here's what we stand for. This is what we believe in. This is what we're going to do. And so the company is really creating their own safety rules. And then what you can do is you can take those safety rules and use them against them. So very much like the defense uses our own clients' medical records against them, we're going to use their own internal records against them to point to some of the violations that the driver may have done. You can then go back and depose the safety manager and get them to make certain admissions. And it's not law. I mean, just because the company has their own safety manual doesn't mean that that's law. And just because they break it doesn't mean that,
Well, in fact,
they broke the law.
many times they'll actually try to keep their own rules out of evidence. So hey, yes, we violated all of our own rules, but the jury shouldn't hear that, right? So I understand the argument. I understand why they're making it, but it's certainly, I think, a little bit disingenuous to say this is the standard we're holding people up to, but we're not going to hold them to that standard in front of a judge and a jury.
I think when you go to trial, though, most judges are going to let that evidence come in, and you should be able to get a negligence per se jury instruction.
To put a conclusion on this, so there's 3 ways that you hold a company responsible for what the driver did. First of all, if they're in the course and scope of the employment, it's very easy. Right? The law just says the company's on the hook. But then there's also some other steps: negligent hiring, training, supervising. There's safety rule violations, whether they be the rule violations that are federally mandated or the rule violations from their own standards, from the company's own book. And typically, you don't see the whole lot where the company's standards are less restrictive than the federal rule. But if they were less restrictive, meaning, hey, we don't want to do those things, then the federal rules are going to apply. So we just walked through the 3 ways that companies can be forced to pay you after a trucking accident in Indiana.
Lots of other ways.
Yeah, absolutely.
3.
Yeah. Each of those paths gives you a chance to recover the damages that you deserve and sends a message that companies can't put profits over people, which is a huge part of the problem. Cutting corners, they're never doing that because it makes them less money. They're doing that because it's easier. Knowing how companies can be forced to pay is only the first step. The next crucial question is, what should you do right after a crash to protect yourself in your case? In our next video, what steps should I take if I have been injured in a car accident? So if you've been injured in a car accident, watch that video.
Or if you're planning on getting injured in a car accident, watch the video, then you'll know what to do.
Or if you just want some help falling asleep right now, click on the next video. We're going to walk you through the most important actions to take in those first confusing days following the accident, so you don't make the mistakes that could cost you your rights or your recovery. So if you or someone you love has been hurt in a truck accident, don't wait. Watch the next video right now. These steps could make all the difference in your case. We will see you over there.